Hello, everyone. On behalf of the Business and Human Rights Resource Center and our partner, Forum Asia, we are delighted to welcome you to the first webinar in our 2025 Business and Human Rights Treaty webinar series, Treaty Making in Troubled Times. This session is being recorded, and you will be able to access the recording of all the webinar on our website. Also, I take this opportunity to remind you to subscribe to the Resource Center LinkedIn newsletter on the binding treaty. We are sharing the link on the chat. As the title of today's webinar suggests, business and human rights in a deregulating world, we are witnessing a deregulating trend that is undermining some hard-won progress in the business and human rights landscape. Especially painful for the movement has been the Omnibus package, which threatens the EU CSDDD, a major milestone that many saw as a stepping stone towards consensus on a UN binding treaty. With the 11th session of the working group around the corner, the panelists of this webinar will help us reflect on the challenges brought by this deregulating pushback, but also on the renewed significance of the binding treaty and on the opportunity to recenter Global South voices in the process. I am joined today by an excellent panel to tackle this. But before handing over to my colleague, Elodie Ava, Senior Legal Researcher at the Resource Center, who will present the panelists and facilitate the discussion, let me introduce our keynote speaker, Heidi Hautala. Most of you will know Heidi from her long career in the Finnish Parliament and government, and also in the European Parliament, where she served as Vice President from 2017 to 2024. Heidi established the European Parliament Cross-Party Responsible Business Working Group and played a key role in making the EU CSDDD a reality. She is particularly interested in the nexus of trade, development, and human rights, and she now works in a number of international networks and organizations, and as a consultant, advises companies on corporate accountability and sustainability. Few are better placed to reflect on the current deregulating trend sweeping through many major economies, and in particular on Europe's rollback of hard-won progress on business and human rights regulations, as well as the implications for the global movement and the UN binding treaty negotiations. Welcome, Heidi, the floor is yours.
Thank you very much, Laura. And I'm delighted to see that Forum Asia is a partner to this event together with the Business and Human Rights Resource Center. It's an excellent cooperation. And I must say that I very much enjoyed that cooperation during my years in the European Parliament. Now, I want to start from the global north. And just a year ago, there was this expectation that the EU would finally become a fully fledged participant in the negotiations towards the binding treaty on transnational corporations and other business enterprises. The expectation was indeed that the new EU Commission, the second of Ursula von der Leyen, would certainly proceed to draft a mandate for the negotiations after the EU CSDDD had been adopted, and I must say, in quite an uphill struggle, which many of you know. So little did we know. The Commission soon declared a simplification revolution in order to ease the administrative burden of companies. Hundreds of pages of the new Bible, the Draghi report, were adopted, and now they are guiding very much the EU Commission in its endeavors. It only just passingly mentioned the difficulty on companies reporting standards, and it also touched a little bit on the CSDDD. But it has been heavily instrumentalized, which could be anticipated. And one of the consequences has been that competitiveness is seen very much in contradiction with sustainability regulation. And this is a complete U-turn from the EU Green Deal of 2019, which also brought up the corporate accountability directives. Now they are being mutilated under the so-called Omnibus 1. So the Commission President has now dropped her mask. A year ago, she was speaking about simplification without touching the core objectives of these regulations. But now, just last week in Copenhagen in an EU summit, she declared that we do not only need simplification, but also deregulation. Surprisingly, tens of big enterprises which operate in Europe at the same time in the context of that summit, they were wishing that there would be meaningful reduction and in simplification of the rules in strategic sectors without compromising core objectives. So I'm puzzled because now perhaps we have to realize that there are more friends in the corporate sector than we have thought before. Now, the question is, have the politicians gone too far in this revolution of simplification and deregulation? Yes, is the answer. The European Central Bank has repeatedly said that the EU sustainability framework is key to financial stability. And hundreds of companies operating in Europe have called to return to the key elements of that framework, for instance, by going back to the so-called risk-based approach to human rights and environment due diligence, following the UN guiding principles. Now, I have some idea that this might indeed happen, but there are other concerns that I want to touch. But before that, who has had a say on the ongoing review of the EU's corporate accountability laws after they had been recently adopted? The answer is that the big employers and industry associations of just 3 big EU countries, Germany, France, and Italy, got 70% of their suggestions taken on board to the Commission's omnibus proposal. And in the last half year, we have seen that Exxon has been the master of lobbying towards the EU, including to the European Parliament, and it has been very intense. And we will not forget that the CEO of Exxon has publicly declared the EU CSDDD one of the worst laws he has ever seen, and he has appealed to Trump to get rid of it. So a word about the EU-US trade relations. The coercion by Trump with high tariffs has made the EU to agree on a revision of its corporate accountability laws. And this in order to make sure that they do not pose undue restrictions to transatlantic trade, you see. Now, what is the importance of the negotiations towards the binding treaty in these troubled times? Global platforms, as the one we are discussing today, can keep up the flame until the pendulum will swing back again in the global north. I want to quote Anita Ramasastry, who is one of the legal experts guiding this treaty process. She says that what is now seen is rather a bump in the road than a sign of permanent decline of business and human rights. I tend to agree with that, and that gives me a lot of hope. So these treaty negotiations are the only truly global platform, and one where the global south has a strong participation. That is also the voice of victims of corporate abuse. Most often that is caused by companies from the global north, and the victims are mostly in the global south. But we of course know that there is modern slavery also in the EU. And let me point out that the recent advisory opinion of the International Court of Justice on the climate crisis also says that the states do have a duty to protect human rights against the climate crisis, and also touching the responsibilities of companies in their jurisdictions. And very importantly, that the victims have a right to compensation. So looking again at the UN guiding principles, the first pillar is the duty of states to protect human rights. The second pillar is the duty of companies to respect human rights. And crucially, the third pillar is about access to justice and remedy for victims. Unfortunately, as we are speaking, the EU's omnibus risks to remove the current EU-wide harmonized civil liability regime from the CSDDD. This would lead to a fragmentation to 27 different EU member state regimes. And even more worryingly to me, Omnibus is proposing to remove the obligation of overriding mandatory application of the provisions from CSDDD. This means that in a case where the applicable law to claims is not a law of an EU member state, access to justice cannot be guaranteed. So, leaving victims without access to justice, there cannot be real accountability of harms, and due diligence would be made just a mapping and reporting exercise. And there is more. The binding treaty in this situation could obviously try to fill serious gaps in national accountability laws. I studied an article by Ekaterina Pannebacker in the Conflict of Laws website. And she says, the original CSDDD approach might have the potential to open new avenues for further practical and conceptual development of this conflict of law doctrine in the future. So she's speaking about the problem of the civil liability now in the CSDDD. So it has a potential, but unfortunately, it seems that there's a real risk that it will be made irrelevant. So looking to the global south, we see many promising developments in business and human rights. In Southeast and South Asia, in Africa, in Latin America, Central Asia, everywhere, steps can be seen towards mandatory human rights and environmental due diligence in different ways and different degrees. While the global north has, at least for the time being, a weakened voice in the treaty process, the lead by the global south is ever more important. To sum up, from the work of 20 years in the business and human rights field in the Business and Human Rights Resource Center, it is very clear that voluntary standards are never enough to eradicate corporate abuse and for bringing better practice. So regulation is the most critical element in ensuring rights of corporate behavior. And it is critical to hold on to the gains that the CSDDD represents. But it is equally important to note that the process has inspired global interests and regarding especially due diligence very much so in the global south countries. So the treaty is a global south-led initiative, and therefore the work on the treaty is very timely. Thank you very much.
Thank you, Heidi, for this insightful contribution. And I think it really primes perfectly today's discussion. But before introducing the panel, just a couple of final technical points. So as the audience, you can ask questions to the panel throughout the webinar with the Q&A box. And we ask you to please have a concise and clear question, and wherever possible to direct it to a specific speaker. You may not see the questions, but we are receiving them and will address them during the Q&A session at the end of the webinar. And then to make sure that this session is interactive and that you can also engage with the conversation, we're now sharing the links to 2 questions on the topic speakers will reflect on. So you can also give your input, and then we will share the results after the discussion. So you should now be able to see those links. But now, let me introduce our speakers. So we have Ben van Peperstraten, who's a senior EU advisor at Anti-Slavery International. Previously, he was a senior legal advisor at the European Centre for Constitutional and Human Rights, and is an expert on business and human rights. He's worked extensively on the UN Binding Treaty, the EU CSDDD, and other global, regional, and domestic corporate accountability initiatives. We then have Dr. Caroline Litschuma. She's a postdoctoral researcher at the Center for Human Rights, Erlangen-Nuremberg. And her current research critically analyzes regulatory developments in business and human rights. She has a PhD in international human rights law from the George August University in Germany, an LLM from the New York University, and also an LLB from the University of Nairobi. And she's a co-rapporteur of the International Law Association's Business and Human Rights Committee, and also co-edits the Business and Human Rights Journal blog. And then we have Pratana Rao, who's leading the Business and Human Rights program at Forum Asia. And she's working on issues of corporate accountability and environmental justice in Asia. So welcome all, and thank you for joining us. But so to start to continue the discussion, let me first turn to Ben. And, Ben, following Heidi's remarks, can you reflect more on the amendments to the EU CSDDD under negotiation, and also on the argument that these seek to ensure competitiveness of EU companies, as it was mentioned before?
Yes, thank you very much. Thank you very much to the Resource Center to also convene us at this timely moment to have this discussion. And thanks for Heidi to set the scenes in which I can indeed delve a bit further in what the omnibus simplification proposal actually entails. I think Heidi already covered a lot of ground, and I think we can see the proposed amendments maybe in a couple of categories. So on the one hand, we see very visible changes to the duty and the enforcement mechanism. So the omnibus simplification package proposes, for example, to no longer look at the full what they call chain of activities, or you could colloquially call a form of value chain, but instead limit the identification to direct business partners and only go to indirect business partners when you have reasonable information or a form of information to suspect that there might be something going on in an indirect business partner. So this is one of those first very visible changes into the duty. Another one focuses specifically on stakeholder engagement, where the omnibus proposes to, on the one hand, limit the definition of who's a stakeholder. And here they mainly aim to limit out stakeholders that are not either directly affected or representing. So, for example, think about national human rights institutes, think about NGOs who work on the environment, etc. So they calibrate or they limit who can be considered a stakeholder, and they also further limit when stakeholders need to be consulted by companies. Further in the duty, they also, so the CSDDD went maybe, because it's a legal instrument in that sense, had to sometimes be a bit clearer than soft law instruments, and came very clearly with a duty to disengage when harms, well, potential or actual impacts could not be reasonably resolved, and there was no perspective of it being solved, and if staying there would actually be a greater harm than disengaging. So that duty to disengage is also proposed to be removed. And then finally, when we're talking about the duty itself, the monitoring whether the actions a company are taking, normally under classical human rights due diligence, a company needs to regularly check whether whatever actions they're taking are actually getting an effect. Normally, this was on a yearly basis, and the Commission proposed in its omnibus simplification package to do that every 5 years instead of every year. So in that sense, also maybe at a more technical level, significantly reducing the potential effectiveness. And there's a second group, well, a second amendment, which is very much focused at the climate transition plans, because next to a human rights due diligence obligation, the CSDDD also contained an autonomous separate obligations for companies to develop and implement a climate transition plan where they could and should indicate how they're actually going to align their own behavior with the objectives of the Paris Agreement. Well, the obligation to put this into effect is removed under the Commission proposal. And then the third bucket of changes proposed by the Commission was also to make the enforcement mechanism, I would say, less stringent or less effective. So on the one hand, the CSDDD foresees that member states have one or several competent authorities who can investigate, who can receive complaints, etc. But when it comes to sanctioning, the instrument foresee a maximum minimum threshold of the amount of penalties. So how do you calculate penalties was also foreseen at the level of the directive. And there the Commission says, okay, let's loosen this up. We can give much more space to the national member states to define what kind of penalties there need to be, and we can give some additional support and guidelines. So that was significantly weakened. And then last but not least, but also important for enforcement, was the obligation for member states to provide access to their courts in case there was a harm as a result of a failure to prevent or address impacts through civil liability. And as Heidi also mentioned, to ensure that the laws of the European Union in that sense would be applicable to disputes as such. So that is the proposal of the Commission. In C, it's a mix, but of interventions that each and individually would weaken the impact of the CSDDD. However, a number of these interventions also mutually reinforce themselves to become a much more significantly weakened package. The Council, however, so once the Commission sends a proposal, it goes back to the Council where the Member States sit and to the European Parliament for them to debate. So the Member States themselves said, okay, we can actually go further, and we will also propose to reduce what is called the personal scope. So which are the companies it applies to? There where the original CSDDD looked at companies with 1,000 employees, or the head of a group of 1,000 employees, the Council proposed to raise this ceiling to companies with 5,000 employees. So 1,000 employees is already very large companies. 5,000 employees is very, 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 very large companies that it would only apply to. And then maybe a last element of the proposal is, and that's a bit more technical, normally directives, and in that sense, actually similar could be said about a UN binding treaty, lay a sort of minimum floor under which member states cannot go under. So they need at minimum to foresee what's in the directive, but member states can show more ambition and are also encouraged to show more ambition. But this specific directive also has what they call a maximum harmonization clause. So this does the opposite. It foresees a ceiling. Member states cannot go beyond either. And also that specific, very technical element is proposed to be increased. The scope would be increased of that specific element, both under the Commission proposal and the Council proposal. So what is happening there is that the nature of the directive changes a bit from something that is a minimum harmonization throughout the European Union to a very strict carcan of you cannot go less than these and these and these obligations, but you can also not go beyond. So in that sense, member states are then in a position that they need to go exactly at what the directive prescribes in terms of, for example, corporate obligations. It's very technical, but it's very important also when we discuss specifically the binding treaty and the policy space that the EU or individual member states have in negotiating a global legally binding consensus there. So that's the proposal as such. I think when looking at the arguments, this is the more difficult part for me to answer because when we look at the proposal and when we look at the politics around, we see actually little to zero real arguments being proposed. I think Heidi has already rightfully mentioned that this is done under a flagship of simplification, less costs, and more recently also deregulation. But if we actually look at what the Commission produced, normally in normal times, the Commission would go out and gather all evidence possible in a so-called impact assessment. And then from there collate it and say, okay, based on all the evidence, this is the best course of action. And in addition to that, the Commission should also, according to its own rules at least, consult all stakeholders, set up a stakeholder consultation as part of the process of developing any proposal. With the Omnibus simplification package, both of these steps have been skipped. So there is no evidence collected, no evidence presented. And in that sense, it's a bit like arguing with somebody who doesn't argue, because the Commission is actually taking opposite policy proposals than what it proposed 4 years ago when it came out with the original CSDDD. And at that moment in time, they actually based it on evidence, on a very thorough set of research. Now there is no research, there's no impact assessment. So they come up with opposite proposals, and you don't really formally know where those proposals are coming from. But I think, as Heidi very eloquently already put out, what is very striking is that the actual proposals that made it into the omnibus simplification proposal are exactly those that business associations were asking for, that large companies are asking for. And so recently also SOMO demonstrated that everything that Exxon has asked of the Commission was actually granted in the omnibus simplification proposal. So there is really a mismatch between what is claimed there and what is actually going on there. Because take, for example, maybe the central proposal that or argument that is being vehicled, competitiveness, reducing bureaucracy, etc. If we actually look at the proposal itself, it actually does the opposite than that. I think Heidi has already alluded to it, that the CSDDD was very deliberately aligned with international standards, such as in the UN Guiding Principles. The omnibus proposal actually tries to do something else. For example, I mentioned that rather than looking at where the highest risk is in a full value chain, it looks first at the direct business relations, independent whether that is a high risk or low risk situation. So that kind of deviation of international standards is actually not reducing costs. It's actually, for lots of companies, increasing costs, especially those companies who have been frontrunners, who have been investing voluntarily in their own behavior, in their own mechanisms, in their own systems, in aligning with the international standards. They now need to potentially shift into a direction that is very new, and that, as we've seen in the German example, is actually often counterproductive and cost inefficient. Similarly, I take the example of civil liability. Heidi has also mentioned that the original CSDDD said, okay, we're going to apply the law of the European Union, at least for the corporate duty to prevent impacts and to address impacts. The omnibus proposal proposes to remove that. So that means that you can easily go to more than 200 different constellations of what is the law that is applicable to a dispute. To me, that seems actually very inefficient, because rather than having one law to deal with that, a law that companies will know, a law that judiciaries will know, and a law that claimants will know, they now go for a vast patchwork of applicable laws. And in that sense, I think will actually increase costs to victims, companies, and judiciaries in applying that law. So I see actually much more complexification, bureaucratization, and allowing access to justice only for those who have the means. So I don't think the argument of simplification really holds here. I'll leave it at that. Thank you very much.
Thank you, Ben. And now let's turn over to Caroline. In your research, you highlighted an issue that's sometimes overlooked, which is the legitimacy problem of applying global north rules unilaterally to global south countries, where we recognize that most of the time global south countries are the most affected by corporate abuse. So can you just reflect more on this, please?
Thank you very much, Elodie, and thank you to the Business and Human Rights Resource Center and Asia Forum for organizing this, very timely webinar. As we sit here, I think the treaty sessions will be resuming in the next 2 weeks or so. So it's really a good time to reflect on the progress that has been made and is being made within the context of the binding treaty, as well as other developments such as the CSDDD. So let me start by, of course, thanking first of all both Heidi and Ben, because everything they say resonates very deeply with my own research and with the kind of work that I've been doing in this particular space. And then I'll move in a little bit of a different direction, because as Elodie has mentioned, my work primarily focuses on the interplay between the global north and the global south in the BHR space. But I'd like to begin by saying that whenever I think about the global south in this context, I immediately go to the rights holders, right? So not the global south as a state or global south states, because sometimes there's quite a bit of a disconnect between the global south states and the global south right holders. So for the discussion that I'm going to have, I always want to begin by asking myself, when we think about laws such as the CSDDD or other human rights due diligence laws, who are the humans in these laws? Who are the humans that are meant to be protected by these laws, right? And when I begin the conversation, or when we begin the conversation reflecting on this, I think we immediately have certain concerns about not only the lawmaking processes, but also the way the laws are designed, and then eventually whether these laws are going to be effective. So Elodie asked me to think about the question of legitimacy. And I want to approach this from two perspectives, the idea of input legitimacy and the idea of output legitimacy. And with input legitimacy, I would have us reflect on how these laws are being made in the global north, right? So using the CSDDD as our case study, both Heidi and Ben have already highlighted the concerns around lawmaking in terms of who was involved in the processes of coming up with these laws, right? So on paper, theoretically, there were public consultation processes preceding the enactment of the law. But in reality, we know that there was very minimal global south involvement in the lawmaking processes themselves. And then this is even compounded within the context of the omnibus, where, as Ben has just mentioned, the EU Commission went against its own better regulation guidelines. Even the EU Ombudswoman is currently investigating the whole process, because you say that you had public consultation, but who is the public in this context, right? The public is certainly not global south stakeholders or rights holders for whom the laws are arguably being made for in terms of making their human rights and environmental situations better. And then in terms of the other aspect of output legitimacy, how can we expect these laws to perform the intention that the regulators tell us the laws are for, i.e. to reduce the corporate accountability gap, to make companies internalize the human rights and environmental costs of their activities, if the laws are not shaped in such a way that there are spaces for global south right holders to engage within the context of due diligence processes, for example, right? So if you think about the way the CSDDD is framed, one sort of silver lining in the CSDDD was including a provision on meaningful engagement and meaningful engagement of stakeholders, because this has the potential to open up spaces for global south stakeholders to rightfully participate in these due diligence processes in order to help make the situation in terms of human rights, protection of the environment, or even climate better. So as opposed to leaving everything to companies, meaningful engagement really has the power to open up this space in the way that the UNGPs actually anticipate. But again, as we've heard from Ben and from Heidi as well, the idea of meaningful engagement is now threatened, right? We have a situation where who is considered a stakeholder, that is shrinking, the space is shrinking, and then when a company is expected to meaningfully engage, that is also shrinking as well. Now, I believe that this has ramifications for how effective due diligence laws are going to be in reality. If we don't consult the very people who are suffering the human rights and environmental violations, then chances are very likely that the measures that are put in place in order to perhaps mitigate or prevent certain adverse impacts are not going to be able to rise to the, to the merit of what is actually required. So then when I think of unilateralism and when I think of these ideas of a legitimacy deficit, when we see the EU acting unilaterally in this particular context, I have certain concerns in the back of my mind. I ask myself, are we seeing regulatory imperialism, right? So unacceptable paternalism on the part of the EU, when the EU makes laws for the whole world, quote unquote, because these laws are going to have a global application, but they don't create adequate spaces both in the lawmaking processes as well as in the processes of implementation for global south stakeholders to be properly involved in these processes. And then for me, this leads to a second concern. Are we going to see the entrenching of already existing power asymmetries between global North and global South actors. And you see this very clearly with the dynamics between companies and right holders. Companies are powerful. Some companies are even more powerful than certain global South states. And yet the way the laws unilaterally are being made, not enough is being done in an attempt to rebalance these power dynamics. And then thirdly, I also rather cynically wonder, are these just feel-good laws that people want to be able to say on paper, hey, the EU is amazing, we made this great law, and then in reality, nothing changes for stakeholders. Now, because of all of these concerns around unilateralism, I initially had optimism about the UN Business and Human Rights Treaty. And Elodie, you forgive me for being very pessimistic even about this treaty process. And I'll tell you why. Let me say cautiously optimistic, but more cautious than optimistic when it comes to the treaty as well. At least on paper, and I agree completely with Heidi in this regard, the UN Treaty gives us an opportunity for multilateral development of business and human rights norms. And this is something we greatly need in this particular field, because at least here you have the opportunity for different states, global South states, to be seated at the same table as their global North counterparts and to take an active part in shaping the future of the BHR debate. However, the concern, and I'll just take one more minute to finish my initial submission here. If you think about the processes of making the treaty, we see now that it's, as Heidi again mentioned, it's a very bumpy road, right? So from the very beginning, from 2014, when the treaty process was being started, this was being pushed primarily by global South countries, so South Africa and Ecuador primarily, and many of the global North countries have been very resistant from the beginning up until now. So Australia, for example, has said they don't want to participate in the treaty process because the treaty is too detailed, it's too divisive. The US didn't participate up until the 7th session, and then it only came in to say, we don't like this treaty that you guys have been working on for the past couple of years. The EU, for me, is the biggest shocker because on the one hand, the EU has been driving for the CSDDD, and then on the other hand, they don't want to actively participate in the treaty process. Why, right? Like, if you are the champion of human rights and environmental protection that you say you are, this is an opportunity to further that on a global stage. So the treaty may be promising, but the reality is that there are conflict lines between the global North and the global South that we just seem to not be able to get over. So even as we put some optimism in the treaty, I would ask that we also, perhaps look beyond the treaty, look beyond what is happening in the EU, and look at what developments are taking part in global South countries themselves. So for example, in Africa, there are many national action plans that are being developed in business and human rights, so at least 5 as at last count, with Ghana being the very latest country. Kenya just this year adopted, so Kenya was the first country to come up with a national action plan on business and human rights, but they just came up also with a draft guideline on human rights due diligence that applies both to private and public companies. And there are many countries in Asia, so Indonesia, Thailand, that have mentioned that they're actually going to go into the mandatory human rights due diligence process as well. So thinking about a smart mix of measures, right, means that we can't afford to focus only on one thing, only on the treaty or only on the CSDDD. We need to go beyond that. We need to look both nationally and internationally, both mandatory and voluntary measures that are happening even in the global South in order to fully, perhaps have hope in the BHR agenda. Thank you very much.
Thank you, Caroline. And then I think Pratana, really to follow on from Caroline was saying, if you could tell us more about the impact of this deregulation that we've seen on communities in the Global South affected by corporate abuse, and especially, I think, in Asia, because that's your region.
Thank you, Elodie. And hi, everyone. I'm Pratna, the Business and Human Rights Program Manager at the Asian Forum for Human Rights and Development, also known as Forum Asia. And we're very happy to co-organize the webinar series with the Business and Human Rights Resource Center. So we're a regional membership-based human rights organization. And our work is primarily through members and partners to ensure that the most impacted by business operations are centered in decision making, and that development is never at the cost of communities. So we've heard from Heidi and Ben and Caroline about some of the challenges related to CSDDD, the omnibus proposal, the UN binding treaty on business and human rights, as well as the legitimacy deficit in some of this discourse. And I wanted to bring a little more of a grassroots civil society perspective on deregulation and what it means. I think firstly, when we talk about deregulation, it can sound like a technical or an economic issue, but on the ground, it's a deeply human issue. And I think that's what we need to always remember. It's about people losing their land, workers losing their rights, communities losing their say over what happens to their lives and their environment. And across Asia, we see that deregulation has become a convenient word for something that is much harsher, which is basically removing protections in the name of profit. And all over the region, we're seeing massive infrastructure projects, extractive projects, building of dams, mines, industrial zones, all pushed through without proper environmental impact assessment, social impact assessments, free, prior, and informed consent, and meaningful consultations, as Caroline was saying. And the message to communities when this happens is that your rights are an obstacle to development. And that makes deregulation really dangerous because it makes it more and more challenging for communities, for workers, for defenders to advocate for what they deserve and to get justice for remedy and harm. So when governments and corporations say that deregulation is meant to create an enabling environment, the question is really enabling for whom? Because for communities, it has enabled exploitation, it has enabled displacement, and it has enabled repression. We have documented case after case of human rights defenders being harassed, arrested, or even killed because they're protecting their land, they're protecting their forests, their people, and many of them are indigenous community members, women, environmental defenders. And these defenders are always conveniently labeled anti-development if they speak out. But the truth is that they're just standing up for a vision of development that is fair and inclusive and sustainable. But deregulation actually makes their work more dangerous. And what I wanted to highlight is that this isn't happening by accident. It's part of a broader, almost race to the bottom, where countries are told that to attract investment, they must cut regulations, they have to offer tax breaks, they have to make it easier for companies to operate. So governments compete to see essentially who can offer the lowest standards, the cheapest labor, and the least resistance. And all of this comes at a cost because what it really creates is a cycle of dependency, of impunity, where corporations benefit and where communities pay the price. And when people, of course, seek justice, and when they go to courts or they raise complaints, they face huge barriers because companies hide behind complex value chains and say that it's the government's responsibility. And then the government says that their hands are tied because it's tied to investor agreements or trade deals. So justice just ends up falling through the cracks. And the people left behind in those cracks are communities and defenders. And that's also why we see value in the legally binding instrument on business and human rights, because for years, actually decades, we've tried to look at voluntary commitments, CSR reports, soft guidelines. But as they say, voluntary principles don't stop bulldozers. So there's a need for something much stronger. And a binding treaty can help close the justice gap because it makes it clear to corporations that they have real enforceable obligations and not just moral ones. And it also allows affected people to seek remedy across borders because when companies operate globally, they hide behind jurisdictional loopholes. But having a legally binding instrument will hold companies accountable across jurisdictions. And so that helps protect human rights defenders and communities. And it also reminds states that economic growth can't come at the expense of dignity and environmental integrity for communities. And what I want to just bring it back to is that I think for communities in Asia, this isn't really legal jargon. It's about survival. And it's about being able to live on their land, breathe clean air, get fresh water, work safely and speak freely. We cannot keep allowing the global South to become sacrifice zones for the global North. And it's about fairness. And if corporations can move freely across borders, then justice should be able to move freely across borders as well. And that's where deregulation, we need to remember, it's sold as progress, but in reality, it's often the removal of protections for the most vulnerable. And it's a policy choice that prioritizes profit over people. But across Asia, we see defenders communities fighting back, building solidarity, building networks to challenge this narrative. And they're proving that accountability isn't about being anti-business, it's about being pro-communities and pro-humans. So it's about building an economy that serves people and not the other way around. So I think when we talk about the treaty, we should remember who it's really for. And when we talk about deregulation, we need to remember that it's about the worker who's denied her wage, or an indigenous leader who's criminalized for defending his forest, or it's about a family whose air and water is being polluted, waiting for justice that probably will never come. So they deserve a system that protects them and not just takes away their rights. And I think that's why this debate and discourse around deregulation has to remember who this is for and who we're fighting for. And that's when we need to also take into consideration that without communities being at the table, there is no way that we can actually create any sort of instruments, binding or voluntary, that serves them. Because we're still then trying to adhere to a system that is meant to exploit them. And I think that's what deregulation is trying to do. And that's why we need to keep fighting back as civil society. So I'll stop there and hand it back to you, Elodie. Thank you.
Thank you, Prat, for really highlighting the realities on the ground, and especially in Asia, about what's happening at the global North level. So, as mentioned at the start of the webinar, we encourage you to ask questions to our panel through the Q&A, and we've seen questions coming already, so that's great. So you can continue to ask questions. And while you do that, we're going to have a look at the questions that you responded. So Nidhi, if you can share your screen. And in the meantime, I'm going to just read the first question, which is, use one word to describe your thoughts on the rollback of the EU CSDDD through the omnibus proposal. So I think we probably all agree on that, but in the word cloud, so the biggest word we can see is disappointing. We also have retrogressive, disappointment, which I think really summarizes quite well what was said as well. Even somebody put ExxonMobil. And then we can move on to the second question and the results for this one, which was what are some of the key elements to include in the UN binding treaty on business and human rights to strengthen corporate accountability. So here we can see different proposals, so some about universal competence of national courts, risk-based approach, reporting, direct interhuman rights obligations for business. So there are quite a few, ideas here that I think can also be helpful for colleagues advocating. Thank you, Nidhi. So now we're going to move on to, and something about legal liability as well, which, you know, as we talked about civil liability at the start of the webinar is super important. So now we're going to move on to the Q&A. So I'm going to start with one for AD. So in your experience, how can we make states to increase their participation in this process, even to disagree, bearing in mind the context of liquidity crisis of the UN?
Yeah, it's indeed very sad to see that the only thing that Donald Trump has to say about the UN when he went to the General Assembly is that he could not enter the escalator or something like that. Well, we know why. But I think it would be great to raise a little bit awareness of the treaty negotiations as a kind of an interactive platform for exchanges. So, I mean, obviously, one day, hopefully, there will be a legally binding UN convention with monitoring mechanisms like all UN conventions. So that was also a little bit an answer to the question of implementation and monitoring. There were two questions on that. But perhaps, how could I put it? I see at the moment, and I think especially we have heard about that from Caroline, but there's quite a lot of different level developments on business and human rights worldwide. And I think we have to see that they, at best, they point to the same direction. So in a way, we are moving towards a kind of a semi-harmonized playing field for companies, hopefully protecting rights holders, as we also have heard very much from Prata as a necessity. So I think it's useful to see that some other international organizations are quite active on promoting seriously responsible business conduct. And I have to mention, well, of course, UNDP is promoting national action plans according to the UNGP in many, many countries, and with, I think, interesting results. Then we see the UNDP regional business and human rights forums. So maybe to point out that the Geneva negotiations once a year can be a kind of an event where different actors, different countries can compare their notes. And also, lastly, I want to say that it would be good to have OECD to be fully sort of present in those negotiations. I don't know in what role, because the OECD has now inspired, especially the Southeast Asian countries, which want to become OECD members. And to many, to the surprise of many, perhaps in this audience as well, OECD is at the moment one of the most ardent promoters of business and human rights. Would you have believed that 5 years ago or 10 years ago? Maybe me not.
Thank you, Heidi. And now there's a question for Ben. What lessons can we learn from the omnibus proposal when we address the UN binding treaty instrument negotiations?
Well, I think the main lesson, the absolute main lesson, is that the work is probably never complete. So even when you think that you have an instrument, you only have it as long as you protect it, as you implement it, etc. So I think it means that as civil society, we need to be thinking in terms of the long-term game. We need to think 5-10 years ahead and also plan our collective struggle in terms of 5-10 years. So that means, and I think that's important because it opens space for movement building, because movements are slow. They take time to construct, but they are tenacious. And I think that tenacity is going to be important because it's going to be a very, very, very long and uphill battle. And so we might get small wins, but we will also see, and I think this is what the CSDDD very much shows, companies are getting, are awakening to these laws. Companies are going to fight back. I'm not saying all companies, But Exxon, for example, is one of those companies that woke up and fought back. And this is going to happen at various places, and companies are very pragmatic on where they intervene. They see an opportunity now with the new commission in Europe, but the next time it's maybe somewhere else, etc. So that means that we need to have a strong, a broad, and a solid movement across the world that has a vision and a capacity to organize around this battle, not for 5 years, not for, oh, we have a law here and now we can move to the next file, but to think more in 10, 20 years, like, okay, we need a law, we need to improve it, we need to strengthen it, we need to deepen it, we need to implement it, we need to litigate it, we need to review it, we need to improve it, etc., etc., etc. So I think that's maybe the main lesson, that yeah, the victory is only as strong as we keep it on.
Thanks, Ben. And then Caroline, given the symbolism of a UN treaty, how much substance should favorable states and civil society be willing to compromise to achieve a broad consensus, do you think?
Elodie, this is the million-dollar question, I would say. Let me give 2 quick responses to this. One, I think that it's important to acknowledge that a human rights treaty, such as the draft Business and Human Rights Treaty, even beyond sort of the final text, the legal text that we'll end up with, even beyond implementation, it has important symbolic effects, right? So just because we have some difficulties in coming up with a treaty, or, I can see some of the questions in the chat, people feeling like, does it even matter that we have a treaty? Will people ratify it? Will it be implemented? I think even if the treaty is not ratified by as many states as we want, it's important to have a human rights treaty because, one, it gives us the opportunity to increase awareness on this issue, the need for corporate accountability. It gives us an opportunity to empower and recenter victims in the conversations and all of that. And then on the other hand, now more directly to your question, I think even as we seek consensus, there are certain bottom lines that have to be present. So for instance, for me, one bottom line is Article 6.4 of the third revised draft of the treaty on human rights due diligence. It talks about the state duty to protect, and it incorporates, as the UNGPs did, this idea of human rights due diligence. But actually, Article 6.4 of the revised draft goes further than the CSDDD because it requires, within the context of human rights due diligence, that states include climate due diligence. Ben had mentioned that this is in peril due to the omnibus. It talks about the need for a gendered perspective. It also talks about the need to recognize the special needs of vulnerable right holders. And it gives a whole list of who are vulnerable right holders. So for me then, even as we're negotiating and trying to come to a sort of balanced consensus that will allow us to eventually have a treaty, I think what's the point of having a treaty at the end when certain provisions are taken away so that the treaty is so weak that it can't really make a difference in the lives of right holders. So maybe the question should not be only about consensus, but it should be consensus geared towards protection of rights holders, always.
Thanks, Caroline, for attempting to answer this quite complicated and challenging question. And now I have another one, and probably the last question for Pratt, which is: do you know any good legislative initiatives in Asia about business and human rights? Are there laws being discussed, like in Thailand, for instance? So if you could give a few examples.
Sure. So in Thailand, so there is the draft mandatory human rights due diligence bill that has just come out, and that is being discussed right now, and that is directly connected to Thailand's aspirations for OECD accession. And similarly, in Indonesia, there's also been efforts to try and become an OECD member. So there is also discussions for Indonesia starting to talk about a mandatory human rights due diligence bill. South Korea has developed the mandatory human rights due diligence bill as well, and it's under discussion right now. And this was developed with civil society, trade unions, and so these are some of the examples in the Asian context. And hopefully one of these will get passed soon. But I think more than that, what is important to remember is, number one, how the bill was drafted, who it was initiated by, and what kind of stakeholder consultations were held in the lead up to these bills being drafted and then eventually, hopefully, passed. Because in some of these cases, at least in the situation in Thailand, we're seeing that since it's directly connected to its hope to become an OECD member, it's now being rushed. And that is something that is, it's being rushed without proper consultations, because the intention isn't necessarily to have a thoughtful, meaningful bill. So I think that puts into question the intention behind such mandatory human rights due diligence bill. But I completely agree that I think as a starting point, having any sort of binding national legislation on business and human rights is a great first step to ensure that there's some kind of document to hold companies and subsidiaries accountable. So yeah, off the top of my head, I can think of South Korea, Thailand, and Indonesia. Thank you.
Right, thank you. And I'm afraid that's all we have time for. We are already a bit over time. I just want to really thank our speakers. I think the discussion was really, really helpful, and it really opens the way for, you know, many more discussions and also advocacy from civil society for a binding treaty. And thank you also to our audience for attending. We are looking forward to continuing this dialogue, and so we'll have another webinar next Tuesday on the 14th of October, and it will focus on the question that actually Pratana was talking about: who is a treaty for? So, you know, we're going to see what it means to create a victim-centered treaty that takes into account the harm suffered by women, also people affected by armed conflict. And we have really great speakers from different backgrounds, and Anita Ramasastry, who's a former member of the UN Working Group on Business and Human Rights, will give the keynote speech. So we're really looking forward to seeing you all there. And once again, thank you very much. Bye.